You may begin.
Good afternoon. I am Dr. Doris Schriero, Special Advisor to the Commission on Immigration and a panelist on today's program, Access to Counsel in Immigration Detention in the Time of COVID-19. And that's sponsored by the ABA Commission on Immigration and the ABA section of Civil Rights and Social Justice. This program is just one of a series of rapid response webinars the ABA has been providing, and the ABA is planning on actively doing others. And so please keep us in mind and visit americanbar.org/CRSJ for updates. And now, before we begin our program, it is my great pleasure to introduce the president of the American Bar Association, Trish Refo. President Refo began her one-year term as ABA president 3 weeks ago on August 4. She is a partner at Snell and Wilmer in Phoenix, Arizona, where she concentrates on complex commercial litigation and internal investigations. From 2014 to 2016, President Refo served as chair of the ABA's Policymaking House of Delegates, and she has also served as chair of the ABA's largest practice group, the Section of Litigation. President Refo, thank you for your leadership and for joining us today.
Thank you so much, Dora, and thank you everyone for joining this important and really timely webinar on access to counsel in immigration detention in the time of COVID-19. My thanks also go to all of our speakers and to the members and staff of the ABA Commission on Immigration and the Section of Civil Rights and Social Justice. The Commission is an invaluable part of the ABA as it provides authoritative national leadership on the legal aspects of immigration, asylum, detention, and immigration courts, focusing on due process and other constitutional protections. And the civil rights and social justice staff and leadership have literally worked nonstop throughout this pandemic to, among other things, put on extraordinary programming like this one to help us address the important issues of the day. A year ago, which kind of seems like a century ago, given everything that we've been through since then, I was the ABA's brand new president-elect last August, and I had the opportunity then to join our president, Judy Perry-Martinez, to observe and volunteer at ProBar, the ABA's pro bono asylum representation project in Harlingen, Texas. That trip was for me as inspirational as it was eye-opening. Judy and I did a lot of listening and a lot of learning from the dedicated staff and volunteers there and from the clients, one of whom I represented. I came home from South Texas grateful for the chance to shine a spotlight on ProBar and convinced, frankly, that there is no better way to tell the public who we are as lawyers, because lawyers are the ones who ensure that people's rights and civil liberties are protected. Due process and the rule of law have no meaning if there are not lawyers there to enforce them. And as Justice Kennedy said, the rule of law means that, quote, the law must devise and maintain systems to advise all persons of their rights. And I believe in that, and I believe that in helping people to realize and to defend those rights, lawyers are truly the guardians of our democracy. The American Bar Association is the vehicle through which many of us try to serve out that guardian mission. And if you're an ABA member, I want to say thank you for your support. If you're not an ABA member, I hope perhaps this webinar will give you a reason to give us a try. Take a look at our website and understand the other benefits that American Bar Association membership has to offer. We meet today, obviously, at a moment of great challenge for our nation and on the topic of immigration and all of the other legal issues that we face. We choose to do what American lawyers have done since lawyers helped to found this country. We choose to get to work to solve the problems that are in front of us. We are the largest voluntary association of lawyers in the world. And boy, do we have work to do. So let's get after it. Thank you all again for being here and for all of the critical work that each of you does to support our goal of ensuring that our profession meets the American promise of justice for all. Thank you.
Thank you, President Refo, and thank you so much for your commitment and your leadership in helping us raise this issue to such an audience. Hi, everybody. My name is Elizabeth Taufa. I am your moderator for today. I am a staff attorney with the Commission on Immigration with the ABA. I oversee the Commission's hotline, which reaches individuals in ICE custody throughout the United States. We focus on providing legal information and pro se case assistance, and we also focus on conditions of confinement and advocacy with government offices to address violations of the ICE detention standards. I just wanted to jump in and provide a little bit of background information. We wanted to provide this program mostly because access to counsel has always been such an important issue and such a difficult issue, especially with people in immigration detention. Most immigration attorneys and advocates will tell you having a lawyer in immigration proceedings often means the difference between winning and losing your case and staying in the United States or having to be removed. And accessing legal representation is a significant challenge for all people in immigration proceedings, but especially for those who are detained and especially for those who are detained in remote areas without a lot of resources. The COVID-19 pandemic has really presented some very serious challenges for lawyers and advocates in accessing their clients that are detained and vice versa. In-person visitation was suspended back in the spring, and measures have been taken by ICE to try and address those issues. But there are still many, many problems that exist, as our panelists will discuss a little bit later on. So before we get started, I wanted to provide just a little bit of background and context information. According to a 2016 report published by the American Immigration Council, only about 14% of detained immigrants actually have an attorney, which means that the vast majority of detained immigrants will go forward on their cases without an attorney on their own and present their own cases. And they are more dependent on other legal resources such as law libraries, legal rights presentations, and access to legal service providers through phone and other technology who can help answer questions and guide them in the right direction, even though they're not representing them. And according to some ICE statistics that were released last week, there are currently just over 21,000 people in ICE detention, which is down from about an average of 50,000 last year, I believe. 53% of those who are detained currently are detained due to a criminal conviction, so they were in criminal custody, most of them, and were transferred to ICE custody at the conclusion of their sentence. 15% were pending criminal charges or had entered the criminal justice system in some way, but had not actually been convicted of anything. And 32% were detained for other immigration violations, meaning that they have no known criminal history in the United States or anywhere else. Additionally, as of last week, there were a total of 3,102 individuals who were detained that had established a credible fear of persecution and were waiting to present an asylum case. And that's important because those people were previously more often than not released into the United States, and that's not necessarily happening right now. So we're going to go ahead and get started. During today's program, we definitely encourage you to ask questions of the panelists through the Q&A function, not the chat function. If you do not see the controls, please make sure that your screen isn't idle, and we can address any questions at the end of this panel, time permitting, of course. We will be sharing a recording of this program for everyone who's registered so that you can share it widely with your networks. We encourage you to do so. And with that, we are thrilled to bring you today's program entitled Access to Counsel in Immigration Detention at the Time of COVID-19. Our panelists today are really a wonderful, esteemed panel of people with wonderful experience that they're going to share. So first we have Syed Ismaili, who is an Equal Justice Works Fellow at Americans for Immigrant Justice based in Miami, Florida. Her work is focused on immigration detention centers and conditions of confinement in the facilities in Florida. She has an aim toward creating alternative systems of accountability through independent conditions monitoring, direct representation, and advocacy on behalf of detained non-citizens. We then have Denise Gilman, who is a clinical professor at the University of Texas Law School and director of the Immigration Clinic there. Previously, she served as the director of the Immigrant and Refugee Rights Project at the Washington Lawyers Committee for Civil Rights and Urban Affairs, and as a human rights specialist at the Inter-American Commission of Human Rights at the Organization of American States. She was also the director of the Mexico Project at the Lawyers Committee for Human Rights, which is now Human Rights First, and she is currently a member of the ABA Commission on Immigration. And finally, we have Dr. Doris Schriero, who is our special advisor on the ABA Commission on Immigration. She previously served as the commissioner of the Connecticut Department of Emergency Services and Public Protections and the Connecticut Homeland Security Advisor. She was the director of both the Missouri and Arizona Department of Corrections and was also warden and later commissioner of the St. Louis City Division of Corrections. She was also previously the commissioner of the New York City Department of Corrections and served as a senior advisor to DHS Secretary Janet Napolitano on immigration detention and removal, and was the first director of the Immigration and Customs Enforcement Office of Detention Policy and Planning. Thank you all for joining us and taking the time today. And with that, I will turn it over to Dora to get us started. Dora, I think you're on mute.
Hello again, everyone. I am just thrilled to be here with you today, and I'm going to touch on topics. First, a quick overview or an orientation to the different kinds of detention facilities and detention standards that there are. And I have to warn you, my internet connection is unstable, so fingers crossed. And I'm also going to talk about the facilities that are governed by those standards. And then quickly recap the what I'm calling 6+1 detention standard, you and your clients' access to counsel. Along the way, I'd like to think out loud with you about the impact, indeed the efficacy of ICE, a national enforcement agency, using two different sets of expectations to hold all of the facilities accountable for detaining one single population equitably under the law. So first, a little bit of the numbers and building on some of Elizabeth's introductory remarks. ICE has agreements to house detainees right now in 232 facilities in 30 states, and these are operated by both the public and private providers. Right now, the census has dropped considerably since October, the beginning of the fiscal year, when it was in excess of 50,000 individuals on a day, now down to about 21,500 individuals a day. Let's see. One of the things that's really striking, despite this really significant drop, some of it COVID related, is that ICE has still booked in almost 170,000 men and women into its custody this year. And so it speaks again to numbers, but also lengths of stay. But it's a huge number of people that they touch. And so the consequences of getting it right, of course, are considerable. Now, ICE operates two types of detention facilities, those that hold detainees less than 72 hours and those that hold detainees more than 72 hours. Currently, and I'm just going to throw a couple more big numbers at you, of those 220 facilities that are in use today, 165 of them hold people more than 72 hours. And I say all these things to you because you have different clients at different times, and we're providing you with links so that you can look up your facility and it'll tell you what kind of people are housed there, and then that will lead you to the specific set of detention standards that govern that particular facility. So it's a little bit confusing, but that's how it's been made. Now, ICE expects all the facilities to comply with its detention standards, but not every facility has to comply with all of the standards. And specific to our conversation, of the 55 facilities that hold detainees less than 72 hours, access to counsel, specifically detention standards 6.3 and 6.4, and so that's law libraries and legal materials and legal rights group presentations, are not required of those 55 facilities. You know, in the criminal justice world, those first couple days are some of the most critical. You know, you're making lots of decisions, and to be in a facility that doesn't have those resources is really quite worrisome. So let's just talk a little bit about the detention standards themselves. Now, again, I'm going to toggle back and forth between the criminal justice system and the civil system. I'm very mindful that they hold different people for different reasons, but I do so because ICE has predicated much of what it does based on correctional practices. So in correctional systems, many systems have adopted standards because these standards set a bar for performance below which a facility cannot fall and expectations to which it should strive. INS, which preceded ICE, also promulgated detention standards, and now ICE has picked up and carried forward. But unlike the standards that correctional systems use, which have one shared set of expectations for incarcerated individuals, and they're based on case law and statute, and that would be correctional case law and statute, ICE detention standards are based on correctional standards, not on immigration case law. And they're also determined by the kind of facility, that is whether they're dedicated ICE only and 72 hours, or non-dedicated, which are shared use, meaning it's an ICE population and one or more other populations that could be over or under over 72 hours. Generally, and so I got a lot of rounding that I'm doing in this conversation, generally dedicated facilities are assigned either the 2008 or the 2011 performance-based and national detention standards, and those non-dedicated facilities generally are using the 2019 national detention standards. Okay. So what's the difference? Is performance-based. And so what that means is the PBNDS, the performance-based national detention standards, set out both expectations and practices, those that are expected. And that really matters because without quantifying these activities and outcomes, the likelihood of just checking off boxes and not making the intended difference is going to be far more likely. And performance-based national detention standards have more boxes to check, and that's a good thing because they offer 44 performance-based national detention standards, whereas the NDS has only 31, and that's an appreciable difference. And where there is, but I just want to add, that the number of standards is important, but it's also the nature, what's in the standard that matters as well. And so what I'm going to show you in a little bit is where there is a specific standard that is in both the PBNDS and the NDS, there are often differences, substantive differences, and sometimes the NDS turns out to be better than the PBNDS. And I'll point out a few of those in a moment for you too. But before I do, I just want to leave you with one last of those wondering thoughts, and that is that all detainees have a right to equal treatment. So why should the conditions of their detention vary only because of the facility to which they were assigned? So, and as I mentioned before, your booklets, both the one for the 2011 PBNDS and the 2009 NDS, have those links so you can determine which govern your client's facilities. All right, so the standards, and we've got a slide that we will pop up. So you'll see that there, what I've done briefly is to lay out the performance-based from the regular and national detention standards. And as I've pointed out already, the PBNDS I think creates value because it articulates expected outcomes and practices. Plus one detention standards that I'll be discussing is correspondence and other mail. And this will be largely true for phone access and visitation as well. each of these assures that detainees are able to have contact with their legal representatives, either prospective or actually engaged, as well as embassies, the courts, consulates, consistent with facilities' overall requirements for safety and security. And you'll see that there's basically not much difference between the two sets of standards that are on the slide. From your client's perspective, something that's important for you and for them to know, and is not always clearly stated in either the ICE Detention Handbook, which provides an overview of what I'm sharing with you, or with the facility-specific detention handbook that the facilities are supposed to issue to newly admitted individuals into a facility. But a takeaway from mail is that both guarantee that postage and envelopes will be afforded for indigent detainees. The difference with NDS is it specifies that at least 5 pieces of legal mail, that envelopes and stamps will be provided for. The next of the detention standards specific to access to counsel is phone access. And again, as I said, it's to ensure that they can have communication with legal representatives, both contemplated and engaged. And here again, the takeaway is that both of these sets of standards require that detainees have the ability to place direct and free calls to legal service providers, among others. And they can do so, as I was suggesting, in several capacities for several reasons: legal representation in pursuit of, or to engage in consultation about an expedited removal case, and also once engaged with providers or organizations who are on the ICE free legal service providers list. So that's an important caveat. The performance-based standard also specifies that indigent detainees representing themselves pro se, also have access to free phone calls. There is a COVID-19 modification, and this is the first of several COVID-19 modifications that we'll be pointing out to you. ICE is affirming that all detainees must be able to make calls to individuals and organizations on ICE's list of the free service providers. And now moving on quickly to 5.7, visitation. Visitation again concerns the ability to visit with counsel, and visit has been enlarged to expand to encompass not only in-person visitation, which has been, the normative way to do it, and in the world of new normal also includes Skype and VCR kinds of communication. One of the really notable differences in visitation between the two sets of standards, and this is a nice example of a positive difference that the NDS allows, is the addition of a new procedure which provides for consultation visits for detainees subject to expedited removal. And again, it begs the question, if it's available to some detainees in certain facilities, why does it not carry over to all detainees in all facilities? The big takeaway when it comes to visitation is that all facilities are required to permit legal visits daily. Daily means 7 days a week, at least 8 hours a day on weekdays, and at least 4 hours a day on weekends and holidays. There is, again, here another COVID-19 modification. And again, ICE is affirming that detainees' access to counsel remains a paramount requirement, and it should be accommodated to the extent possible. Now, what that means is if it works for you and you believe that an in-person visit is preferable, and certainly when you're sharing legal documents and or signing legal documents, that is frequently the best way to do it, that legal visits must continue unless there is an overriding risk to the facility's safety and security. When you are requesting such a visit, a key word to use is to indicate that an in-person visit is essential. At that point, the facility administrator or the warden cannot refuse that visit except under extraordinary circumstances. So that's just a thing that I really wanted to bring to everyone's attention. The next of the 6+1 standards is law libraries and legal material. And of course, the value is for all detainees to be able to either work along with you by reviewing case law that you might be mentioning to them. But the law library is also the place where copies of legal materials are made for detainees. And it is also typically the place where you would request notary service or certified mail for legal purposes. The big takeaway really for you and your clients when it comes to this standard is that all facilities, meaning under either sets of standards, are required to make reasonable and necessary copies of the legal material at no cost to all detainees, and notary public and certified mail service at no cost for indigent detainees to pursue a legal matter. There is here also a COVID-19 modification, and that is that the facilities, keeping in mind the import of social distancing, should expend the hours that law libraries are open and then stagger the access so you're not contacting one another either in the corridors or by having too many individuals in the law library at any particular time. The next of the 6+1 standards is 6.4 legal rights group presentation. And as I noted before, this is really a value added opportunity. And not every facility has it, but where it is provided, it's really an important overview to inform everyone in the population about U.S. immigration law and the procedures that correspond with it. Here again, there's a COVID-19 modification. ICE, this past March, suspended all but the EOIR funded presentations. And so any of the others are not provided. And for the most part, these EOIR funded presentations are being done primarily on a remote basis. But again, they could be done in person. And you now all know what the magic word is. The last of the 6+1 standards, and then we'll get to the one, is 7.4, and that detention standard is detainee transfers. You'll note when you're looking at this slide that sometimes the numbers vary between the PBNDS and the NDS. So here, NDS identifies it as 7.2, and that goes back to the point I was making earlier about the differences between 44 and 31 detention standards and such, so the difference in numbering. So detainee transfers, here again, you see an appreciable difference and in my mind, a significant improvement when it comes to NDS. In the 2011 standards, it says that the legal representative of record shall be notified as soon as practicable. Practical is a word that ICE uses a lot, but not later than 24 hours after the detainee is transferred. And then you see a really appreciable shift in awareness in the 7.2 version, where it says in deciding whether or not to transfer a detainee, so you're well in front of the notification, that ICE will consider. And so this is ICE really talking to ICE and not to the facility because they're making these decisions. ICE will consider whether the detainee is represented before the immigration court, and if the detainee is represented, that ICE will explore alternatives to transfer. So if your client is being moved, just remind them about the commitment that they made about the way in which this was going to be approached. The last, so the +1 past the 6, is Detention Standard 4.8 under PBNDS or 4.7 under NDS. And this really speaks to accessibility. This gives assurances consistent with a variety of federal statutes that all individuals are protected against disability discrimination and any kind of discrimination or disenfranchisement that might result from being limited English proficient. And so the takeaway from both sets of the standards is that both of them address the needs of detainees with disabilities and limited English proficiency. So that's an awful lot very quickly, but I look forward to your questions and comments towards the end of our panel presentation. Thank you.
Thanks, Dora. I got some good questions for you in the chat box, so we will, or in the Q&A section anyway. So we'll circle back to that after everyone else. So now I'm going to turn it over to Denise Gilman, who is going to discuss some of the issues that we've seen in Texas surrounding access to counsel and some other issues that we've seen.
Right. Thank you so much. Thanks to everybody for putting this panel together. Really, really timely. I think I want to start briefly talking about the fact that we are still seeing not only decent numbers, large numbers of people in immigration detention facilities in Texas in the time of COVID, and individuals who are largely in the detention centers that I work with most frequently, asylum seekers, recent border crossers, people with no criminal history, no serious indication of any flight risk or danger to the community, people who have, for the most part, a place to go, family, relatives, who are willing to assist and support them. So in other words, migrants, asylum seekers who do not need to be detained at all. And they are still in the detention centers, have not been released in any significant numbers due to COVID. There has been enough attrition that, as Elizabeth described, the numbers are lower, but they are not diminishing in any meaningful way. This is not something that's on its way out, immigration detention, even in the COVID. And we're seeing new people coming into the two nearest facilities to me in recent weeks. It was kind of calm for a while, and now we are seeing some new intakes into those facilities, mostly, again, recent border crossers seeking asylum. So that's one set of realities. And then the other thing I want to point out before talking about what it's looking like on the ground in terms of access to counsel is which there was always a problem of meaningful access to counsel at the facilities around the country, but the ones that I'm most familiar with in particular, I have some specifics that we've been complaining about for years, and for the most part, the standards have been honored more in the breach than in the true exercise of those standards. So at the Pierce facility that's just south of San Antonio, a very large facility run by the GEO group, there with about 500 detainees, a mix of asylum seekers and others, and actually a mix of women and men right now. We've had a number of problems, but the biggest one has always been that there are only a couple of attorney-client meeting rooms in a large facility. And so that has meant that for the most part, attorneys trying to visit clients at the facility have had to wait for hours to be able to see a client. And when you add travel time as well, what this means in effect is not just that it's an inconvenience for the one client who is waiting to see their attorney and for that prep, but it means that the attorney can take on fewer clients, so you have fewer people represented overall in detention. At the Hutto facility, just to name one problem of many that we have seen for years, and this one ties into what's happening currently, we never had attorney-client confidential space for meetings. And this is a facility also quite large, about 500 women, asylum seekers mostly, recent border arrivals mostly. And we have always had to meet in a series of plexiglass cubicles in an open space where the guards are, where regular non-lawyer visitors are, where other detained women are. And the plexiglass cubicles don't even go all the way up to the ceiling. So they are neither proof nor visually confidential in any way at all. So that's kind of the status quo before COVID hit and made it all that much more difficult. So right now what we're seeing is that, first of all, at both of those facilities, the Know Your Rights presentations that provide critical information to detained individuals, whether they're seeking asylum or some other form of relief, and just information about why they're in detention and how long they will be in detention, which is a lot of the information that is needed to avoid some of the uncertainty and the traumatic effect of detention. Those Know Your Rights presentations are not happening in any kind of group-based fashion at all, which is the way that it used to be possible to get some basic information out to larger numbers of incoming detained individuals. There is some, particularly at the Hutto facility, to allow the main Know Your Rights provider to do individual consultations, but even that is extremely limited because it depends on women in the facility reaching out to the provider, American Gateways, because otherwise there's no way for American Gateways to know who to. And of course, given the kind of level of isolation that is taking place right now and the fact that the provider isn't coming in on any regular basis, making itself known to the women, it's extremely difficult for women to know that service, that possibility even exists. And so that's where we are in terms of Know Your Rights. At both Pearsall and Hutto, okay, actually, I gotta clarify. There's somebody on from American Gateways, the main legal services provider. So I do want, she's noting that they are able to group by VTC, which is great. And I understand that at Hutto, there is some VTC advising, and there is video advising, but I'm pretty sure it is individualized only, and only if a woman is out. I'm more familiar with what's happening at Hutto. Thank you to Priscilla, who chimed in about Pearsall. So that also, actually, as I'm speaking about it, I'll make one more correction. I actually think Pearsall's capacity is much higher. I said 500. I think it's actually close to 1,000. It's just that in recent time, it has been a smaller number. Maybe I'll get a correction on that too. Is that honestly, not many attorneys are going. Just does not feel safe for the detained individuals or for the attorneys to be going into a setting where we know that the facilities are not providing any real opportunity for distancing or for proper hygiene care. In addition to that, the facilities are insisting on pretty intensive requirements of what attorneys must, in terms of protective gear, in order to be able to go in. So I know at Hutto, it's not only masks, but it is also gloves and even eyewear. It may be glasses, but it has to be eyewear as well. Pearsall, I know, is at least masks and gloves. And so that, does really impinge on an ability of an attorney to go. If you can't, on a particular day, make sure that you have all of that equipment and then go out and wait, it makes it quite difficult to the facility. I understand that they are doing also some temperature checks and the like at the facilities, which is probably mainly a good thing, because as I say, there has been quite a bit of concern about whether the facilities can be trusted to keep both detained individuals and attorneys safe. The overall really are not there. So most people are not doing visits in person. That brings us to phone issues. Because really the main way in which people are communicating with their clients, attorneys are communicating with clients in the facilities right now, is by phone. And it has continued to be a problem before COVID. And since COVID, even though the guidance put out has suggested that phone communication should be made easier and more frequent, it has still been very challenging to speak in a confidential phone conversation because many are recorded with clients at the facilities. And so that has been an ongoing issue. It should be possible, and in some cases, after much negotiation, has been possible to schedule phone call appointments that can be a little bit longer, but in most cases, it's either impossible to get a hold of somebody to schedule the phone appointment, or those are being held to very short time periods that really are not sufficient to be able to prepare somebody for an asylum hearing, for example. I did want to mention one more thing about physical visits to Hutto, because it goes back to the plexiglass cubicles. Sorry, I forgot to mention this. So what is happening at the Hutto facility for those who do go to visit the facility is that for the most part, the attorney being asked to sit in one plastic cubicle, while the client, detained woman, asylum seeker is being asked to sit in the other cubicle. And this is ironic because we had been told for years that these cubicles provided confidentiality, even though we said they did not. And now we're being told that we can communicate through the plexiglass to be able to talk with clients, which is problematic in every scenario, particularly in terms of what guards can hear and other detainees can hear, but also just sound quality. But it's even more difficult if, as is often the case, we have an indigenous language speaker and you need to have an interpreter on the phone at the same time that you're trying to communicate through a plexiglass. And it is also extremely difficult to get work signed. So even if you do manage to go out there and you communicate through the cubicle, what do you then do when you need to have an asylum application signed? So usually you have to still come out and meet in the common area or slip something under plastic. I mean, there just is no real effective way to provide counsel in these cases. And so I think it really does come back to what Dora and others said at the very beginning, which is that access to counsel is critical to the possibility of a detained individual to present their case in any kind of meaningful way. And while we already were facing huge obstacles in that regard, the situation with COVID-19 has made it almost impossible, so that the clients are detained individuals really are not having a fair shot at being able to present their cases. And the only real, frankly, is to end immigration detention as we know it. And allow.
Denise, I think we
I was
lost you there.
finished, but I froze. I'm so sorry. That was terrible timing. I think you caught enough of the last part. I was just urging us to think about really needing to do away with detention as we know it in order to ensure any meaningful access to counsel and ability to present cases in immigration court.
Great. Thank you, Denise. That was super informative. And we have some questions for you for the Q&A a little bit later on as well. And so next we're going to move to Syed to tell us a little bit about what she's seeing, as she and her organization are seeing in Florida, and maybe some updates on some ongoing litigation there.
Thanks, Elizabeth, and thank you to everyone, to the ABA, for hosting this webinar and for having me today. I'm very excited and happy to be here. I'll start with saying Americans for Immigrant Justice, the organization that I work at, is a nonprofit legal services provider based here in Miami, Florida. I am on the detention team, and so we provide legal services to detained adult populations at the 3 ICE detention facilities here in South Florida. So I'll go a little bit over those because, as Dora very well illustrated, everything varies depending on what facility you are detained in, right? So first we have Chrome Service Processing Center, which is located here in Miami. It's a facility that is owned by ICE, but it is operated by a private security firm. There is an immigration court within that detention facility, and that immigration court hears cases from not only Chrome itself, but from another facility, Glades, which I'll talk just more about in just a second. There's also Broward Transitional Center, which I will be referring to as BTC. It's in Pompano Beach, Florida, which is about 45 minutes to maybe an hour north of Miami. That facility is owned and operated by the GEO Group, which Denise also mentioned as well, which is a private for-profit prison corporation. There's also a satellite immigration court there in that facility, and that court only hears cases for people who are detained in that specific facility. I should say both Chrome and BTC are subject to the 2011 standards. And then lastly, there is Glades County Detention Center, which is in Moore Haven, Florida, which is about 2 hours northwest of Miami near Lake Okeechobee. It's a county jail that is operated by the Glades County Sheriff's Office. And so that particular facility has long had access to counsel issues, particularly given the remote location of the facility. Certainly no exception during COVID as well. And that facility is subject to the 2019 standards. So in a pre-COVID world, we would regularly go out to the facilities and conduct free legal consultations, provide Know Your Rights presentations, and of course represent people in their immigration matters, right? We would be out at the facility several days a week. We would could show up to a facility with a list of names, and we would be able to meet more or less with everyone that we would request to visit with. Now in a COVID world, a lot of what our work looks like is changed really dramatically. We are working from home and we haven't been to a facility since March. We are still conducting legal consultations as best as we can, but it is over the phone or over Skype. And so before I get into the more nitty-gritty of what we've been seeing, I do want to echo everything that has been said already. That access to counsel, particularly in the immigration context, has long been an issue, by no means is new, and nevertheless COVID has served as a way to escalate this already really dire issue. And even if we are to think back about, even if we were to go back to how it was in a pre-COVID world, I think it's important to remind ourselves that that detention really, is another form of family separation, as well as a form of deteriorating and eroding rights to due process, right to counsel, and all of the ways that someone can meaningfully present a case in defense of their deportation. Another thing that I'll just add is a reminder that the detained docket moves much faster than in the non-detained context, right? So not only time is not on your side as well when it comes to being detained and in removal proceedings. A person is not working, and so they are less likely to be able to pay for an attorney. Oh, sorry, are there audio issues with me? Can you hear? Okay, saw someone in the chat saying, sorry about that. And so yes, no one's working in detention, right? So there's less ability to pay for an attorney. There's less time to collect evidence, less ability to collect evidence if you're detained. So all of these factors play in, right, to a meaningful opportunity to actually have due process in your own proceedings. So I'll talk a little bit about what are the populations that we're seeing in detention here in South Florida. Because of COVID, we are seeing a number of transfers not only within Florida, but nationwide. We've been seeing a lot of movement, a lot of shifts within people who are detained in ICE custody. At Chrome and Glades, we generally see a lot of community members and who are either apprehended by ICE directly in the community or who have been transferred over to ICE custody on an ICE hold or a detainer. So among those people are people who have lived, here for some time now, have established lives here, including time green card holders, for example. At Broward Transitional Center, or BTC, it's largely a population that consists of asylum seekers. We also see a lot of people who were arrested at the airport, for example. So a lot of more recent arrivals who are detained at that facility. And something relatively new that we've been seeing within the last few months in South Florida is we've been seeing a lot of Cubans specifically who were put in the MPP, or the Remain in Mexico program, and they were later transferred after being ordered removed, being transferred from the border to Florida. So we're seeing specifically that population a lot locally. So how have we been communicating with people since March? It has definitely been interesting, and we'll have to, be scrappy and reinvent a lot of the ways that we work. But so at BTC, for example, back in March, actually, Geo installed 4 computers, so 1 in each attorney-client visitation room. And as Denise mentioned about the lack of sufficient number of rooms in facilities, that is also an issue that is existent in this facility as well. There are only 4, but only 2 of those computers have Skype capabilities. So there are some tech issues with Skype. Sometimes the guards don't answer our calls, for example, or sometimes Skype is unavailable because it's already being used. But for the most part, it's somewhat okay. However, there is an issue for people who are in quarantine. They will not be called over for any type of legal call. So of course, that hinders any type of attorney-client meeting or communication for people who are in their quarantine. At Chrome and Glades, the access issues are we're seeing a lot of them. Neither ICE nor the facilities themselves have really implemented any type of systematic process for any type of streamlined attorney-client communication. So at the early onset of the pandemic, local ICE recommended to our local AILA chapter the use of Getting Out, which is a text messaging platform, right, that is used for people who are detained more generally to communicate with their families and their loved ones. This recommendation is, as I'm sure you all can imagine, very inadequate for many, many reasons. It's particularly for us as pro bono attorneys, for example, people should not have to pay to access us, to talk with us. And yet now they have to. So that's a problem. Another issue that we have is that we have to wait for people to add us as contacts. We are not able to add people as contacts because that would, involve putting money into people's accounts and things that we unfortunately just don't have the resources or the capability to do. Another issue is that the platform is not confidential. We mostly use it to schedule calls, but we will not use it to really deliver any type of substantive information because it's not a confidential platform or space. And alarmingly also, the facility itself where the person is detained in has the power to shut off someone's account. So for example, I have a client right now whose account was suspended for any disciplinary reasons, and now it's even harder for me to be able to communicate with him because the one little sliver of opportunity that we were recommended has now been taken away. So I'm gonna talk a little bit more on the granular level now of what we have been doing, right, to try to communicate with people who are detained locally in these facilities. So let's say someone, a family member or loved one contacts us to let us know that someone that they know is detained in one of the facilities. So we have that person's information. First, we will share instructions with the person who contacted us to tell, hopefully that they could pass on the information of how the detained person can reach us. We will also send them a letter with written instructions on how they can add us on the text application. And if and when, and it's a big if, unfortunately, because we send out a lot of letters and a lot of information on how people can add us, but unfortunately the burden does fall on the detained person mostly when they, in order to get in touch with us. So once a person has added us on the texting platform, we schedule a call, a telephonic, so that we can move forward with a telephonic legal consult. Even when we finally do schedule a call, there are a number of barriers to that as well. So sometimes there's no phone available at that particular moment when we've scheduled a call. Sometimes the call cuts out, the phone lines are not great, or we're also contingent on the facility schedule, right? So during count times, for example, the whole facility kind of comes to a freeze, and no phones are operating at that time. The call that is made to us is also made from the pod or the housing unit, right? So sometimes it's very loud in the background. Sometimes, as I mentioned, the phones aren't great. And most importantly, it's not a confidential space at all. People are hesitant to share sometimes sensitive information about themselves and their cases because they're in a crowded housing area, and also because of the phone, because they're on the phone, right? They can't see me, I can't see them. It makes it really hard to establish a meaningful rapport with someone when you're just over the phone and you really can't sit with a person face to face. And so this is a big issue for us now, because now we have this growing list of people who, would like a legal consult, and the list grows, and our ability to be able to communicate is not as effective as we would like. And as Denise mentioned as well, I mean, you could try to schedule legal calls through ICE. For us, it's been pretty hit or miss. It is contingent on the person that you are speaking to, the ICE official that you are speaking to. Like I mentioned earlier, there really is no systematic or standardized process for this. I will say one slightly positive thing that has come out of this is that our ability to have an interpreter during a consult has substantially improved. In a pre-COVID world, it was largely very difficult to request visitation with someone in a room that has a phone where we would be able to call in an interpreter. We were often told that we could come and bring an interpreter in person, which logistically is just not realistic or feasible. And another facility also would not provide us a confidential space, even if they did grant access to a phone. So recently, that is one positive thing that we are seeing, is that we are able to call in an interpreter on the line. And of course, that also presents its own issues, because speaking with someone through an interpreter takes much longer, and given the time constraints and the noise in the background, there are still hurdles, but it is something that we've been able to work with. We do rely a lot on the mail. I would say even more than before, whether it's to mail letters to schedule calls, or to send a person instructions on how they can contact us, or sending legal documents. And of course, we, as everyone else around the country, are affected by the slowing mail times and the turnaround times. And while all of these things are happening, we have to remember that people's cases continue to move forward. So while we try to reach out to people, provide information, or provide some representation, people's cases do move forward. And it's especially crucial in those initial stages of when we're still, interviewing people, providing the intake or the consultation, and all of these things take time. As I mentioned earlier, my team, unfortunately, at this moment, we're not going out to the facilities. There are attorneys who are. Similar to what Denise shared, there are requirements for PPE and I believe I've heard of some temperature checks as well at certain facilities, but I've also heard very concerningly that they're not adequately enforced. So maybe you'll see someone without a mask, or so it's really, it's give and take. I will say one of my colleagues did have a bond hearing over the phone just yesterday. And she reported that even though, I mean, she was able to represent her client over the phone, which we are not seeing consistently, that judges are granting telephonic motions for telephonic appearance. So that's another issue. But for her case, it was very difficult because apparently the judge could see the client, but she was just appearing on the phone, so she could not see the client. So, and also the translator who was also on the line was giving simultaneous interpretation, and so that presented an issue for my colleague to be able to adequately hear the immigration judge. So there's a lot of moving parts in terms of telephonic representation and issues that we're seeing with that. And as I mentioned, all of these factors are really, unfortunately, deeply impacting our ability to take cases, and are also deeply impacting the type of cases that we are able to take. And I will end with just a quick mention about some ongoing litigation that my office, as well as some other partners, are working on. The name of the case is Gale versus Field Office Director. It is a federal class action filed here in the Southern District of Florida on behalf of detained people who are detained in ICE custody at the 3 facilities that I've mentioned. Originally, the complaint was filed asking for the release of the people who are detained in the 3 facilities due to COVID. However, the case has largely turned into a conditions case. The judge has certified the class only as 2 conditions. So while she has not issued any decision yet on releases, she has ordered that ICE follow certain guidelines on the actual conditions within the facility, the facilities. More recently, the judge also appointed a special master to inspect the 3 facilities. At this point, the inspections have all been completed. We are waiting for the report, which will be coming out within the next few days. And all of these access issues in our work on this litigation have really hindered our ability to be able to adequately figure out what is going on inside the facilities, right? My team has been working as a primary point of contact between the people who are detained in the facilities and the rest of the team of attorneys who's working on this case, and to work to get declarations, to get information gathering on what exactly is happening inside the facilities. And given that we are unable to go, all these access issues feel more dire and more frustrating, really, as we continue to work on this litigation. One way that we have been able to work around these issues, we set up a hotline for people to be able to call, and fortunately they can call for free. We created a hotline especially for this litigation. It's open 4 hours a day, Monday through Friday, and people can call to report issues in the facilities or get an update on the case. We had the advantage that we already have the pro bono speed dial, so people can call us for free, and so that has really been a huge help to us in communicating with people who are detained. And with that, I will stop there, but I will echo everything that has been said, and we're in a serious point here where we really need to revisit how we view detention. Thank you.
Thank you, Syed. That was very informative, and actually a very good transition. I know that we've been fielding some of the Q&As that we're seeing, so I just wanted to hit on a couple of things. So this webinar is actually a piece of a larger project. The ABA has recently published 2 handbooks on the ICE detention standards, both the PBNDS and NDS. Regarding the access to counsel issues that we've discussed. Those are available on our website, and they're also going to be circulated with the rest of the resources from this webinar. So, we've kind of given an overview of some of the relevant ones, but those go into much more detail. The other piece of that is an advocacy guide for individual advocacy for your clients or anybody that you happen to be working with in detention right now, with a list of ICE offices and different contacts and different tools that you can use to try and do some advocacy on these access to counsel issues. So I very recommend taking a look at those. They're very informative, they're very in-depth, and please reach out to us if there's any questions about that. And then I would also be very remiss if I did not also make a plug for pro bono volunteers for our organizations. Clearly there is an issue, there's a lack of counsel, there's a lack of competent counsel, and we're really trying to make sure that we really start adding to the legal field so that we can, really help to advocate for some people that are stuck in detention, maybe have been stuck in detention for an extremely long time, without cause. So if you're interested in volunteering, both the Commission and AIJ love volunteers, and we would love to have more of them. AIJ is based in Florida, so if you're in Florida or near Florida or want to work in Florida, we will be circulating contact information for volunteers in the Florida area. And then also, if you're interested in volunteering with the Commission, we'll be circulating that information as well. We do have offices here in DC, so our hotline is based in DC, so if you're interested in that kind of work, you can contact us. But then we also have offices and pro bono opportunities in both Harlingen, Texas, down on the border, and in San Diego, California, also on the border, different border. So if you're interested in any of that, please reach out to us, and we will do our best to try and set you up some pro bono opportunities. Okay, so we're getting some good questions out of the Q&A, and I think that we should start with the one that's kind of like a far-reaching question, is who's in charge of paying attention to these standards and making sure that ICE is actually doing what they're supposed to do according to their standards? I think that's probably a good place to start, is with Dora on that one.
I'll take that one, thank you. Yeah, I saw it came up quite a bit, and it's an important question. So this is fundamentally ICE's responsibility. They contract with all these providers to operate these facilities, but they are never alleviated from the ultimate responsibility for the care and custody of everyone who's being held under their authority. ICE has several measures by which they do this. They retain the services of one group, which has been soundly criticized by Congress. And this private group does annual inspections. You can find their inspections on the website. You go to ICE facility inspections, pretty straightforward. Scroll down to your facility. You will see that the summaries are quite brief, and they're also heavily redacted. But what there is available there. One of the COVID-19 modifications was the suspension of those facility inspections this past March. Something else that was interesting that came up, ICE has revised what it calls its pandemic requirement. It's PRR, lost one of the R's for a moment, but this instruction that they issue was modified twice, most recently July and again in August, having been soundly criticized for being so hands-off to the facilities in the way that they were issuing instruction. They committed to doing what they call spot checks bi-weekly in those facilities that are over 72 hours in their clearance level. I haven't found anything online to indicate that these have begun yet, nor do I have any idea about what they look like, but just by characterizing them as spot check suggests that it's a pretty light touch, whatever it is that they do, whenever it is that they start doing it. The Department of Homeland Security Office of Inspector General, so the DHS, OIG, and the GAO, the Government Accounting Office, have both on a pretty regular basis issued reports critical ICE's oversight of facilities compliance with the respective detention standards. And just last week, I believe it was last week, in the last very short amount of time, the GAO has released a second extremely detailed and very lengthy critique of ICE's oversight of detention facilities and compliance with detention standards. When I was at ICE, I established an office called ODO, the Office of Detention Oversight. It was purposely established outside of what was DRO then and is now ERO, the Enforcement Removal Operation, which is the group that's responsible for doing a lot of enforcement activities and, of course, having general oversight of the detention facilities. Oh my gosh, I just lost my train of thought. Well, I apologize for that. But at any rate, oh, I'm sorry, I was saying about ODO that it was intentionally set up outside of ERO so as to give some distance and hopefully some greater neutrality in its assessments, i.e. be more hard-hitting and plain-spoken about what needed to be addressed. ODO still operates and when assessed by OIG or GAO, receives better reviews than does the work of those private vendors. But that is a largely underfunded enterprise, and so the frequency with which ODO goes out is typically once every 2 or 3 years, and only at a limited number of facilities. So, you know, really, if you're going to do something of this scale, of any scale, you really need to be full in and allocate the resources and evidence the resolve to take actions when there is non-compliance, particularly on a repeated basis.
Denise, I think you're on mute.
Yeah, sorry. I mean, just really quickly, I wanted to just say 2 things. One is I do think that the guides that especially Dora have produced are essential because it is absolutely true that the squeaky wheel, the attorney who cites to the guide and insists on access, has a chance at getting access, and the detained individual has a better chance of speaking with their attorneys. The problem, of course, is that it's cyclical. If you don't have access to counsel, then you don't have counsel who can the standards to fight for greater access to counsel. But with that said, that means that all of us who are working in the facilities should do more and more to insist on that access so that we don't normalize a situation where meaningful access and confidential communications are really the exception, because then just normalize the situation and it becomes worse and worse. So I wanted to mention that. But then I did want to also just tag on to what Dora is saying about oversight, and note that Detention Center, for example, which I just described as having these cubicles that have never been confidential and even more problematic in current day, the contract for that facility there with CoreCivic was just renewed for 10 years. And so until there is a really robust way in which fulfillment of the standards, meeting the standards, actually a condition of ongoing contracting, it's going to be very hard to make progress. So I think that's an important place that we all need to be seeking to intervene.
Thanks, Denise. Yeah, that's actually a really good transition into the next question. We've got a couple questions about the issues of confidentiality that everyone spoke about, and how that's sort of hindered representation and access to counsel just generally in the facilities, whether by phone or in person, where in-person is happening, and kind of what's happened in order to try and either assert the right to confidentiality as a legal provider or to address that in any other way. So I don't know if Denise or Syed, one of you, wants to take that one.
Yeah, I mean, I will say when I'm speaking to anyone on the phone who's detained and they express some sort of hesitance about speaking freely on the phone, I mean, ICE has told us that our pro bono line, for example, is not monitored or recorded. And so I do tell them that, but I also, you know, just a friendly reminder to take that with a grain of salt, right? Because all we have to really confirm that is ICE's word. And so, yeah, it is an issue though, in terms of being able to speak freely and comfortably with your attorney, right? And so there, it's been difficult for us because ICE tells us that our lines are confidential, and so there's no like real advocacy that we can do because there's nothing that we can confirm that they're not. But regardless of whether it actually is or not, there is a chilling effect of having to continue to do some sort of representation virtually, just by means of that.
Elizabeth, if I can, I'll just add to that a little bit. Every facility is set up differently, and that's maddening. And they can change how they're set up too, and not necessarily tell you, although of course they're supposed to. But in general, it would be advisable to speak to your facility and find out if it's not automatic, and it usually is not, then what measures must be taken to assure that either all phones will not be recorded or monitored when a particular phone number is dialed, or which phones are dedicated for that kind of configuration. And it doesn't happen always automatically, and so you want to be sure that that has occurred and not just assume so. Likewise with mail, which is another form of, of confidential communication. The standards are pretty explicit that legal mail is only to be searched for contraband, which means it is not supposed to be read. Although facilities have interpreted that differently, particularly when you've got a gang unit that argues that they want to read material not for that information, but to scan as a search for some indicia of gang involvement. What would be done in the correctional world is legal mail, anything that's marked as legal mail, would only be opened in front of the inmate. And there are detention facilities that have adopted that practice as well, but they are in the minority.
Thanks, Dora. Okay, so I think that we've also gotten quite a few questions about the hotlines that are available. So we have one through the commission. We do answer calls from all detention facilities in the US from 9 to 5 p.m. Eastern time. We have a speed dial code that is 2150#, which should allow anybody in ICE custody to access via the pro bono platform within ICE's telephonic system. If you are having trouble, if someone is having trouble reaching us, or if that pro bono platform doesn't exist in whatever facility, please reach out to us so that we can try to work with ICE to make sure that the facility gets access to that. And there's also a question here specifically for Syed to talk a little bit more about your hotline and how it's set up.
Sure. So just as Elizabeth mentioned, the hotline with the commission, my organization also does have a free speed dial, essentially, from any phone within any facility that is detaining people for under ICE custody. What is tricky about that is that the specific phone instructions vary depending on the facility, right? So even within the 3 facilities that my office serves, there are different phone instructions for each of them. And so let's say even if someone were transferred from Chrome to Glades, for example, the steps that they have to follow on the phone to call us are different. Totally different. And so that's really hard and confusing, and can be really kind of tricky to explain that process sometimes to to people. So that's one issue. The hotline itself, that, or let's say the line, the speed dial that we have, is something that my office, I believe, has had for quite some time now, because we are a local pro bono services provider. Our information does come in on the little sheet that is given out in immigration court under pro bono lawyers, and so I believe it's related to that we are listed as one of the pro bono providers, and that is how we are able to get a speed dial. And our hotline for the Gale, so we have two different hotlines technically. One is for the Gale litigation, which I mentioned, which people can call to report on what they're seeing or to ask for updates. We do have another more general detention hotline where people who are detained can call to provide us their own information if they want a consultation with our office. The hotline for anyone that may know someone who is detained or wants to share that information forward is 569#. Again, that specific phone instructions differ between facilities, but that is our hotline number.
And I will say that if you are part of an organization that wants to be listed with the speed dial codes with the other organizations, you do need to reach out to your local field office in order to get onto that list. It is a list maintained by ICE and their contractor Telton, and they run the entire thing. And as far as I understand, that it is very facility specific. So every time there's a new facility that has ICE detainees in it, they have to go through this whole thing and deal with the facilities directly in order to make sure that access to that speed dial system is actually given. Again, if you are working on that and you need some assistance, please feel free to reach out to us so that we can try and help you get onto that list. It is also very specific, it's geographically specific. So if you are detained at Chrome in Miami, but you were previously detained in Otay Mesa in San Diego, and then you were transferred, your Otay Mesa numbers, your San Diego numbers are not going to work when you are transferred to Florida. So you actually have to kind of engage with ICE in order to get those numbers opened up for you wherever you happen to be. And again, that's another place where if you've got counsel, then that counsel can assist with that. If you don't have counsel, it becomes a lot more difficult in order to assert those rights. But they are there, and so again, please reach out if we can be helpful in that regard. Okay, so I'm looking at some of these. Denise, there's a note here that you would like to answer this question about asylum rules.
That was kind of a mistake, but no, they are not in effect yet. Where they're going to have to process all of those 60,000 plus comments that were submitted. But it is, of course, worth noting that every time the rules for substantive relief, whether it's asylum, other aspect of a case that somebody is trying to present in immigration court, every time that becomes more complicated, the need for counsel becomes all the more urgent, and yet it seems that the restrictions on access to counsel kind of go in step with the restrictions on ability to access relief, eligibility for relief.
Thanks, Denise. There is a question here about the difference between marshal contracts and ICE contracts. I don't know, I think that one was directed for Dora. I don't know if you saw that one.
There are occasions where ICE will access a facility through a U.S. Marshal Service agreement. So they're like, once removed from the facility owner or the facility provider. In the couple instances that I've seen, the U.S. Marshal Service commits that ICE detainees will be governed by the prevailing ICE detention standards, which are always going to be NDS because these are shared use facilities. So whether or not in actuality the facility follows through remains to be seen, and that should be discovered when you have an annual inspection, if not sooner. But under no circumstances should ICE detainees be governed by standards others than those promulgated by ICE, as low an expectation as ICE standards set, and is appreciably lower, quite frankly, than case law suggests for conditions of detention for civilly held people. The U.S. Marshal Service standards are appreciably lower, and that would just be an extremely egregious action if it happened.
Thanks, Dora. And there have been, I think we've got time for maybe one or two more. There are several questions about the differences between the facilities that hold children and the facilities that hold adults, and what kind of safeguards there are for children, especially when children, especially unaccompanied children, maybe wouldn't have the ability to advocate with an attorney on detention conditions or something along those lines.
I'll start, and then I'm going to, I think, hand it off to Denise if she's okay with that. I did not mention there is one other set of detention standards, but we were trying to go for the largest number of people in our presentations. But those are what are called family residential facilities, and there are just several of them, and only one will entertain housing dads as well as moms and their minor children. The others accept moms and children only. Now that's going to be different than facilities where ICE has pulled away children. So I'm going to defer to others about that. But there are these family residential standards. They were promulgated in 2007, and just this year, 2020, updated them. They are neither fish nor fowl. They are not being called either national detention standards or performance-based detention standards. And they've got a little bit of language and a little bit of formatting from each, which is just the way that things are. There are basic assurances when it comes to mail and phone and visits. Law library is a lot squishier. They tell you that it must until they tell you that it may. There's also provision for legal orientation presentations. But for dealing with the kids specifically, I'll hand it off to my colleagues.
Well, so I guess first thing is it's really important to kind of distinguish between family detention, which includes children but who are with their parents, and then unaccompanied minors detention, because the unaccompanied minors detention is actually mainly through Health and Human Services, a part of Health and Human Services called the Office of Refugee Settlement, and the children are mainly held in shelters that are licensed by the state. They're still detention, and there are still lots of problems with that system, but it's a completely different system from what we've been talking about, which is ICE detention. The families, the children who are held with their parents, those are ICE facilities, contracted just like detention with GEO and Core Civic specifically for the most part, except for a small facility in Pennsylvania. There are two large family detention centers here in Texas. The story of legal access at those two facilities is a long and painful one. There was actually a period where we had much better legal access at those two family detention centers. It has just progressively gotten worse and worse, so that it is quite challenging now in all kinds of ways to provide legal counsel in those family detention centers. And currently, for a variety of reasons, there are a large number of families who have been held for a very long time in those detention centers, which were really only meant to be very short term as ordered by the courts, typically no more than 20 days. Now we're talking months and months and months and up to here. So that's one set of issues. For the unaccompanied kids and access to counsel, what I will mention is something I mentioned in the chat, that others in the ABA are more familiar, they're more on the ground with this, but there has been a move to really try to speed up those proceedings for unaccompanied kids. So they're in these ORR shelters, but they are in removal proceedings in immigration court. And in an effort to try to get those to go as quickly as possible, the courts have been holding those proceedings by video to these shelters with kids. So you've got a kid who may not have spoken to an attorney, because it's hard when the proceedings are going that quickly to get attorneys in there talking to them, on video with a judge trying to assert rights. And just as a baseline reminder, I know we said it several times at the very beginning, but to be very, very clear, there is a right to appointed counsel for anybody, including accompanied children in the immigration context. So those kids only have an attorney if they've somehow managed to connect to a nonprofit services provider, and even rarer circumstances, a private attorney who's representing kids. So just want to make that clear, that as far as access to counsel, very problematic for kids as well as adults.
Thank you, Denise. So looks like we are out of time. So I want to just thank you all for joining us for this webinar. We would love, just thank you so much to Dora, Syed, and Denise for being here and sharing your wisdom and your information and your experiences. You're doing such amazing and critical work. So we thank you for taking the time out of your day to be here with us. Just a reminder, the section for Civil Rights and Social Justice is providing free webinars and resources for all legal professionals and advocates throughout the country. And so we hope that this helps in all of the work that you're doing, and consider joining and becoming an active member in the ABA. You can find us online, and you can find more information or other free programs on the CRSJ webpage about different events, CLEs, webinars, anything that you'd like. And please feel free to reach out to us if there are any questions or anything else we can answer. Good luck with the work, everybody. Please stay safe, especially our colleagues in Texas and Louisiana. Please stay safe down there. And thank you again for joining us. Take care, everyone.